Welcome, folks. Can you sue for emotional distress? The short answer is yes. In most U.S. jurisdictions, you can sue for emotional distress. However, it's not always straightforward. Emotional distress claims fall under tort law and typically involve proving either intentional infliction of emotional distress or negligent infliction of emotional distress. The requirements for a successful claim can be quite demanding, as we'll explore. Several elements must be present to successfully sue for emotional distress. First, standing requires you to be a direct victim or a bystander, such as a family member of an accident victim. Second, causation means the harm must be a foreseeable result of the defendant's conduct. Third, damages include compensable losses like therapy costs, lost wages, and pain and suffering. Punitive damages are sometimes possible in intentional cases. Finally, be aware of defenses including the statute of limitations, comparative negligence, and potential immunities. Early intervention can improve outcomes, as shown here. Proving the severity of your emotional distress is a major challenge in emotional distress claims. Courts require clear evidence that the harm was significant and not just temporary discomfort. This often requires medical evidence, such as a psychiatrist's evaluation or affidavit. A professional assessment helps establish that the emotional harm was severe enough to warrant compensation, typically involving conditions like anxiety or depression. Some states still adhere to the impact rule, which requires physical impact alongside emotional distress. For example, you might need to show that the distress came from witnessing an accident or being in close proximity to harm. However, many states have relaxed this rule, especially after 2020 allowing claims based on mental harm alone without requiring physical contact. This recognizes that emotional trauma can be severe even without direct physical impact. Emerging technologies like virtual reality trauma therapy are increasingly used as evidence. These tools can demonstrate the intensity of emotional distress and help validate claims in court by providing immersive simulations of traumatic experiences. Several high-profile cases illustrate how emotional distress claims work in practice. Let's examine 3 notable examples that have shaped this area of law. The McDonald's hot coffee case, with its 2024 retrial, shows emotional distress claims often accompany physical injuries. A customer suffered severe burns and developed lifelong anxiety from the incident, leading to a court award for both physical and emotional harm. The Hulk Hogan versus Gawker case set important precedents for celebrity mental health claims. The court recognized emotional distress from invasion of privacy when private videos were leaked online, affecting the wrestler's mental well-being. The Doe versus Meta Platforms case demonstrates negligent infliction of emotional distress liability for technology companies. Meta's algorithms contributed to suicidal ideation among teenagers by amplifying harmful content, leading to a $1 billion settlement. The landscape of emotional distress claims is evolving rapidly. New technologies and workplace changes are creating new types of harm that courts are beginning to recognize. Expect to see more cases arising from AI-generated deepfakes, where fake images or videos cause severe emotional distress through reputational damage or harassment. Workplace PTSD, related to remote work, is becoming more common, with employees experiencing trauma from isolation, overwork, or virtual harassment. Social media defamation is being amplified by algorithms that spread harmful content quickly, causing significant emotional distress through misinformation and conflict. The 2026 Mental Health Parity Act amendments encourage courts to recognize cumulative trauma, such as repeated microaggressions. Additionally, the EU's Digital Services Act has inspired states like California to require platforms to take responsibility for distress caused by user-generated content. While emotional distress claims are possible, there are important defenses and limitations that can restrict or prevent them. Free speech protections under the First Amendment can limit claims, especially against public figures or when opinions are expressed. There's concern about over-litigation, with some advocating for caps on damages to prevent excessive lawsuits. AI tools are being developed to detect exaggerated claims, with projections showing a 40% rise by 2030, according to ABA forecasts. Progressive jurisdictions tend to be more plaintiff-friendly, while conservative ones impose stricter proof standards. Looking ahead, experts predict significant changes in emotional distress claims. Professor Catherine Sharkey from NYU Law anticipates a 30% rise in claims by 2030, particularly those involving algorithmic harms from AI and social media platforms. The American Bar Association reports that 60% of tort claims now include emotional distress elements, up from 45% in 2020. This surge is closely linked to rising mental health diagnoses, with CDC data showing 1 in 5 adults experiencing anxiety. Globalization may lead to cross-border lawsuits as digital harms span jurisdictions. However, privacy laws like GDPR could limit data sharing needed for proving claims, creating new challenges for international cases. Bottom line, emotional distress law is evolving rapidly. Seek legal counsel to assess the viability of your specific case and navigate these emerging challenges.
Thank you for watching. Please make sure to subscribe, like, and share. We'll see you next time.